Taking a look at the judicial system, the American judicial system, we have 50 federal judicial systems plus the District of Columbia. We have 50 state judicial systems plus the District of Columbia, and we have the almighty United States Supreme Court. So we have quite a large legal system in the United States, and each of these court systems exist independent of each other. One doesn't trump the other. They have their own distinct sets of trial courts and appellate courts, and I'll explain the difference in a moment. But the federal court system doesn't trump the state judicial system. They work independently of each other. Before we can talk about the individual courts, the federal courts and the state courts, we got to talk about something that is relative to all of the courts, and that's something called jurisdiction. And in its simplest form, that is the authority to hear a case, the court's authority to hear and decide a case. And this is based on the geographic area in which the court has a right to, or it exercises the right and power to decide matters involving a person, property, or subject. Now let me kind of go into that a little further. We have this thing called in persona jurisdiction, and those are the people within its boundaries. And then we have in rem jurisdiction, and that's property within its boundaries. So take, for example, Plattsburgh. The city of Plattsburgh is in Clinton County. So I'm just going to take, for example, county court. We have a Clinton County court. Anything that happens, anybody who's in that boundary of Clinton County court is subject, or Clinton County is subject to Clinton County court, and any property that is in there can be subject to the Clinton County court system. So let's take Allison, who steals from Wal-Mart in Plattsburgh, and she gets arrested. And law enforcement take her over to Vermont, court in Vermont. Does that Vermont court have proper jurisdiction? I mean, this is kind of an obvious case. Where'd the crime happen? In Plattsburgh, in Clinton County, in New York State. Does Vermont have anything to do with that? No. So Vermont court would not have a proper jurisdiction. That's how jurisdiction works. Does this court have the authority to hear the case? And in the criminal sense, this jurisdiction issue gets more involved in civil cases. But for purposes of this class and criminal law, jurisdiction is going to be where the crime has happened. So crime happens in the city of Plattsburgh, in the county of Clinton, the state of New York. That's where it's going to be prosecuted. If it's a minor crime, a violation, traffic infraction, or a misdemeanor, the appropriate jurisdiction is going to be city court, Plattsburgh City Court. If it's a bigger issue, a felony, our county court will hear it. And I'll explain the court system in a little bit. But for purposes of this class, if a crime is being committed in the state of New York, some court in another state isn't going to have jurisdiction. And then you break it down to county to the local entity to decide which is the proper court of jurisdiction. So jurisdiction, the authority of the court to hear a case. So let's talk about the state court system. Actually, this is relative to both court systems, is how the courts are broken down. Generally, each system has two distinct sets. They have a trial court and they have an appellate court. This is the same for both the federal court system and the state court system. Trial courts, which is going to be our lowest courts, and depending on where you are, they have various names. They're called superior courts. They might be called county courts. I'll tell you what New York is. I'll show you the map system of New York, of how it's broken down. But trial courts, the very first court. This is the court that hears the questions of fact and the law. This is where the jury is. This is where they're going to decide a criminal case, People versus Smith. Let's say we have Joe Smith, who allegedly murdered Susie Jones. People have to prove the case beyond a reasonable doubt. The people call a bunch of witnesses. They call an investigator. They call the neighbor who heard some scuffling and some arguing. The man standing on the corner who saw Smith run out of the apartment building where Jones lives. They have the knife that has some sort of substance on it. They found it at the scene, and that substance appears to be blood. There's a lab report that tested the substance and, in fact, identified it as blood, and not just blood, but that it has DNA from Jones on it. There's a fingerprint on the knife, and the lab report says the fingerprint belongs to Smith. So that's our case. All of that would be heard in a trial court. All of those facts. The facts are presented by folks like witnesses, our testimony. Various types of evidence gets put in. That is the knife, and that is the lab report, and could be the identification witness who saw him running from the building. All of that is being heard at the trial in front of a jury. That's what the trial court hears. And all of that together, taken as a whole, we call that as a record. And who's taking down the record? If you've been in a court, or maybe on TV, there's a person that sits kind of in front of the judge below the bench typing away, the stenographer or the court reporter. The reporter creates the record, and everything that is said and done in court is recorded. There's always going to be a transcript of some sort, some record. So all of that, and then let's say we have a jury that convicts our defendant and they're found guilty. The defendant can appeal and go to a higher court. But at that higher court, that they call an appellate court, they don't rehash out the case. They're not going to bring in all these witnesses to rehear everything, or, oops, we forgot this, let's add this in. No, none of that happens at the appellate court. The appellate court will get a copy of that record that transcriptionist or the stenographer has taken down, and they will review it and only look at questions of law. Now, what do I mean by questions of law? Any of the decisions that the judge decided in the case will be reviewed to see if he or she made any mistakes. The appellate court in a criminal case will not override a jury verdict. They won't say, the jury got it completely wrong, it should have been not guilty. That's not what the appellate court does. That's not what they'll do. However, if they found that the judge made a mistake, maybe in telling the jury what the law is or allowing some sort of evidence in that shouldn't have been in, then that's how a criminal case gets overturned, or some sort of improper conduct on the part of the prosecution. So it's the appellate court that reviews what happens in the trial courts to determine if it was done properly. So the facts are what happened. This is what happened. And the law is what should be done because of those facts. So think of it that way. We got our facts is what's happening, everything that's happening. And the law, which is determined by the judge, is going to be what should be done about the facts. So this is how our state court system works. Generally, there's 50 states and D.C. And they all have a lower court, and they all have an appellate court. So technically they have the two in the middle. They don't necessarily have, most of them do have like a traffic court where it's all traffic tickets, or a municipal court, and they might also hear some disorderly conduct or some low-level misdemeanor offense. I put small claims there. They also hear small claims, eviction type cases. That's what municipal and traffic courts do. We have those in New York State. I'll outline them in a second. But our lowest trial court that's going to hear a felony case. Let's call it a felony case for murder. My Smith versus, or my People versus Smith case that we just went over is going to be in a lower trial court. And most places, most states, it's called a superior court. New Hampshire, Vermont, Connecticut, and Massachusetts call that court a lower court. Not the same thing in New York. And then their appellate court is usually called a Supreme Court. And it would be the Supreme Court of Massachusetts, the Supreme Court of New Hampshire, the Supreme Court of Vermont. That is the highest appellate court. And in some instances, and it's appropriate to bring up here because most of those instances is a criminal case. The United States Supreme Court, while technically a federal court, it is the Supreme Court of the land, so they will hear cases that come out of state court if they involve a violation of the United States Constitution, which does arise in criminal cases. If you may remember back from an introduction to criminal justice class, you may have learned unusual, harsh, and excessive punishment. The unusual punishment argument, if somebody got a very extreme sentence out of a court, technically the Supreme Court could review that. The Supreme Court can review anything involving an illegal search and seizure. So anything that arises out of the Constitution they can hear, despite the fact that a case may have started in state court. So this is our Superior Court, just to kind of run down the basics that we just talked about. It is a court of what's called general jurisdiction, meaning it can hear everything within its bounds. So Clinton County Court can hear any sort of case that arises within the boundary of county court. I keep referring to county court because it's not called Superior Court here. It's named after the county. So if you're in Essex County or Warren County or Washington County, you're going to have a Washington County Court, an Essex County Court. Whatever county you're in, they're going to have a county court. And it's going to be the court that hears the case first. This is where our juries are. And I'm going to note this is mostly where a lot of the civil cases start. They can't start anywhere else. But this is where our felony criminal cases happen. And this is where the court gets the facts, creates the record. A judge or a jury decides what will happen by applying the law that is given by the judge. So this is our low-level state court, our Superior Court. And then there's a state Supreme Appellate Court. It's normally the highest court in the state. New York has another one we'll talk about in a second. It's the final authority on state law. If you get this far and it makes a decision that's not very favorable for you, there's nowhere else to go unless you think there is a violation of a United States constitutional right, and then you can ask the Supreme Court to hear your case. But in actuality, that's rarer than rare, so usually it ends here at the state Supreme Court. And like I said, it doesn't rehear the case. It will review that record that was created in that lower court, and it will only review the law that was applied to those facts and whether the judge made any errors. Like I said, it will not overturn a jury verdict just because they think it should have been different. That's not how it rolls. So this is New York State court system. This is what it looks like. So let's kind of go through these. This whole bottom row is very important to us with the exception of the New York City Civil Court. So let me start there and work my way across. New York City Civil Court hears small claims, cases, evictions, that sort of thing. I think they have like even a housing component to it that just hears the evictions because they're so big. But for our purposes, New York City Criminal Court, they hear all the low-level crimes, misdemeanors, violations, and violations of city ordinances in the New York City Criminal Court system. In district courts, that is also the Traffic Municipal Court of New York State down in Long Island. Long Island's divided into districts. So any misdemeanors, violations of ordinances, traffics, all happen that are on the island will happen in their districts, and how the island is divided will be dependent on which district court you go to. And then in upstate, we have city courts, town courts, and village courts. And they are the traffic/municipal courts in those areas that hear misdemeanors, violations, and violations of their municipals' ordinances or their codes. So just to break this down a little further, if you're in the town of Plattsburgh or the town of Beekmantown or the town of Westport, which is down in Essex County, you're only going to hear cases involving crimes that happened in that jurisdiction. The town of Plattsburgh isn't going to be able to review or hear a case involving a crime that occurred in the city of Plattsburgh or in the town of Beekmantown. So, jurisdiction. That's only involves their jurisdiction. So now we're going to jump up to the next level. We're going to look at the other gray box, Court of Claims. That's a civil court. If you want to sue New York State or any of its agencies, you go to the Court of Claims to bring it there. No criminal cases there. Then I'm going to jump over to the smaller blue boxes, Surrogates Court and Family Court, just how they sound. We have a court specifically for family court cases. In Surrogates Court, that is wills and probate matters and guardianships, unrelated to this class. But the one smack dab in the middle, county courts. That is the court that hears all the felonies in that county. So Clinton County Court, Essex County Court, Franklin County Court, St. Lawrence County Court. They hear felonies. That's what they hear. They don't do anything else but hear criminal felony cases. That's what they do. Now the one in the middle, Supreme Court, that is our version of a superior court for civil cases. So, divorce cases go there, and, any breach of contract or real estate will happen in that Supreme Court. We don't need to know about that one. Not all of what we're going to do in New York State, all the felonies are going to come out of county court. So then we have this other box. It's got a 1, 2, 3, 4 in it. That's our first step in the appellate court. So if something goes bad in the Clinton County Court, there's a defendant was found guilty, the defendant would appeal to the appellate division. And it's divided 4 ways, dividing up the state in 4, basically. And we are in the northern, if we're in Plattsburgh, we are in the northern district. We are in the 3rd department, which is number 3. Number 4 is out in the western part of the state, and 1 and 2 is downstate, and then 1 is the city in Long Island, I believe, is how they're broken up, 1 and 2. So depending on which county your case is coming out of, the defendant is appealing to, will depend on which of the appellate court it falls into. And then, if you don't like the answer there, you can ask our Court of Appeals. It's not for the taking. You can automatically go from county court up to the appellate. You get one bite at the apple. That's automatic. If you don't like what happens in the lower court, you get the bite at the apple at the appellate court, but you don't get that in the Court of Appeals. You have to ask them to hear your case, and you have to give them a very good issue to review because they're very, very busy. So as you can see, New York is quite a busy, very big and very convoluted, but it works very well because then they can keep courts very systematic. Everything that's family related can go to a family court. Everything that's felony criminal can go to a county court. Everything they can break it up nicely because the state is so big. So let's move to the federal court system. And like the state system, there are 50 court systems, and DC has a federal court system, and they have a lower court and an appellate court, and then the almighty United States Supreme Court. And it works the same way. The district court or the lower court hears the case, the facts, that's where the jury is, and then if whatever and when I say the loser, I shouldn't say the loser in a criminal case. 99% maybe a little less, but it's usually the defendant who is found guilty that appeals. Can the people appeal? The people can take an appeal, but usually the people or the prosecution, their appeals is happening while the case is pending, because once a jury finds somebody not guilty, the people can't go to the appeal court and say, yeah, they got it wrong. That should have been guilty. Like, once there's a not guilty, there's no avenue for the people. It's like, okay, jury decided. But for a defendant, they can have their case reviewed. So most of the time, who's appealing is the defendant, not the people. But the people can, if the judge makes they think the judge made an instant mistake and it's serious to affect their case, the people can ask for the trial to stop or the case to stop so they can have appellate review. They have that power. So we have our lower court and we have our appeals court. Our lower courts and federal court are called district courts. And our appeals courts are called circuit courts. And then there is the United States Supreme Court. I think I have a little map. Yep, there it is. So the district courts, there's 94 different district courts. And like I said, they could be, when you're in a bigger state like New York, there isn't just one. There's 4 district courts. The Northern District Court for the northern part of the state, Southern for the southern part of the state, and we have Eastern and Western districts. And those are our lower federal courts, and the bankruptcy court is also considered a district court, and that's a separate court in and of itself. And then the appeals court is divided into circuits. And as you can see, there's only 13 circuits, but there's 50-odd states. So these circuits are bundles of states. And there's 13 of them around the country. And New York is in the 2nd Circuit, and it is joined with Connecticut and Vermont. So New York, Connecticut, and Vermont are in the 2nd Circuit Court of Appeals. So if a defendant was found guilty in the Northern District of New York in his federal case of trafficking drugs, he would have to appeal to the 2nd Circuit if he wanted review of his case. Can he go to the United States Supreme Court? He could ask them to review the case, but it would have to be a case involving a federal question or a federal issue in order for them to take that case. So here's the types of cases that the federal courts hear. As you can see, they'll hear 7 different types of cases. The ones that are in bold are the most common, and number 1 and number 4 are the 2 for criminal cases. So those are you can look at this list. I'm not going to go through each one. Number 7 involves civil cases, but number 1 and number 4 are the most common for criminal cases. The case arises under the United States Constitution. Right, there's a violation of a constitutional right. And cases involving controversies when the U.S. is a party to the case. Well, the U.S. is always a party to the case in a criminal case because they're the ones that are prosecuting it. The government is the one that's prosecuting it. So when there's a federal crime, they're in federal court. And if the defendant claims there's some violation of the U.S. Constitution, illegal search and seizure, cruel and inhumane punishment, I didn't get a jury, anything like that arises under the U.S. Constitution. And our top court is the United States Supreme Court. And if we were in the classroom setting, I would kind of go around and see if we can name all of these folks. But I think this is our Supreme Court, but I think I'm going to leave that for you to review on the United States Supreme Court website. There is a link on Moodle, and it may even be a part of an assignment. But our 2 newest justices, I'll point out some, are the 2 that President Trump appointed. We have the white hair standing in the back as I'm looking at the screen. Hopefully you're looking at your screen. It's on your left. Neil Gorsuch, and on the other extreme right is Brett Kavanaugh, and almost everybody's favorite, but I think we all know who Ruth Bader Ginsburg is, down sitting in the chair, the only lady in the front row. So this is our Supreme Court. Let's talk about what they do. I actually don't have my slide on what they do. So let me just give you the rundown on the United States Supreme Court before we turn to burden of proof. A little glitch in my slides that I don't have that here. So it is made up of 9 justices. The current Chief Justice is Roberts. It has, technically, the U.S. Constitution gave it the original jurisdiction, as it could hear any case whatsoever. It certainly can. It has the power to hear whatever it wants to hear. But it primarily, in this juncture, it only truly hears appeals from lower federal courts and lower state courts. It's really an appellate court. But there are cases that go right to the Supreme Court, especially when they're involving elections. I think right off the top of my head, the last one that I remember that went straight to the Supreme Court was the determination involving the Gore and Bush election. But they certainly can. How does a case get there? 2 ways: by direct appeal, or something that's called, and more commonly called, a writ of certiorari or writ of cert. You have to ask for permission to hear the case, is what it means. And the person who wants the Supreme Court to hear the case has to prepare a brief request and show them what the what's the issue involving the U.S. Constitution. And if the court decides to hear a case, 4 of the judges have to decide. It could be more than that, but they need a minimum of 4. If 4 of them say, yeah, let's take the case, they're going to take the case. But it's extremely rare. I think they only take 100 or so cases from several thousand that they get asked to hear. So it's a very difficult process for the Supreme Court to hear a case. But if they do take a case, they're not going to rehash it out. They're just going to want a copy of the record. Each party submits some sort of brief and does an argument before them. If you go to their website, you can actually listen live to oral arguments or recorded sessions after. It's very interesting. And I may have you do that because there's a couple great criminal trials coming up through the pike. And if it happens during the semester, I might put some clips to that as part of assignments. But nothing has been stirring since the unanimous jury decision that happened a couple months ago that I discussed last week. So then they decide. And you hope you have a majority, but it can certainly come down a bunch of different ways. But then they reach a decision, and it becomes the law of the land. Everybody has to follow it. So if they overturn a statute, or they deem a statute unconstitutional, it's gone. So they have the final authority on whether a law is going to stand or not if they decide to take a case. If they don't decide to take the case, that Supreme Court of the appellate court of the step down, whether it's out of federal court or out of state court, is going to be the law of that particular jurisdiction. Not everywhere. So if a appeals court in New York, let's say that Second Circuit I told you about, which is the appeals court out of the federal court, if they make a decision, which they did, they made a very huge decision regarding the SAFE Act and the stricter gun controls, the laws that came out of New York and Connecticut as a result of Sandy Hook. There were cases filed in the lower federal court saying how it was unconstitutional, the statute was unconstitutional, and the district court said, no, that is constitutional. And then it was appealed to the Second Circuit, and the Second Circuit said, yeah, that's constitutional. And there was not an application made to the United States Supreme Court to determine the issue, which would have been huge, because I'll tell you, there is no Supreme Court decision regarding gun rights in this country. As shocking as that may sound, they have not made a ruling with regards to the Second Amendment, a huge ruling saying whether it's proper to restrict it or not. But the losing side did not bring an application to the Supreme Court, and it was a very interesting time because one of the justices had passed away, Antonin Scalia, and he was a conservative judge, but the court sat as 8, 4 and 4. So 4 of the justices were more conservative and 4 were more liberal. So if you bring such a controversy case to the Supreme Court, like whether or not you can restrict gun rights under the Second Amendment, you could have a tie. You could technically have a tie 4-4. And if there is a 4-4 tie, the law that came out of the Second Circuit would have become the law of the land, versus it just right now being the law that encompasses Vermont, Connecticut, and New York, because that's the jurisdiction of the Second Circuit. A circuit out on the West Coast can decide something completely different, and it'd be the law of the land there. So that's how important the Supreme Court is and how they can make decisions and turn things up on their head. All right, I think I just jumped the gun on one of the slides here. So as I'm kind of presenting here, if you guys want to just look at that slide that says what is the burden of proof, what is the standard to win, I just want to talk a little bit about that before I jump into the preponderance of the evidence slide. So the burden of proof, what is it? It is the legal standard a party must meet in court to win the case, to win the charge, to win the allegation, or to win the defense, if there's a defense. I touched on it a little bit last week when I was discussing the differences between civil lawsuit and criminal prosecution. There's 2 components to this burden of proof. It's called the burden of production, the burden of persuasion. The burden of production is one's obligation to present evidence to a trier of fact. Who's a trier of fact, by the way? That's the one who is hearing the evidence, the one that has to make the decision. So that might be a judge or it might be a jury, but both of those are considered a trier of fact. And the burden of persuasion is the duty to convince that trier that you have satisfied or met your standard. So whoever's up first, let's say in the criminal case, it's the prosecution who has to, one, they have the obligation to present evidence to the jury, and they have to persuade the jury that they've met their burden. They have this 2-component test here. So let's talk about preponderance of the evidence, because it does come up in criminal cases that we'll talk about when we get to defenses. So it's very important to distinguish between preponderance of the evidence beyond a reasonable doubt. So preponderance of the evidence, when does it come up? I already told you it comes up in civil cases. That's what they need. More likely than not, plaintiff has to show slightly more or better evidence than the defendant. It's kind of like a 51-49, right? The defendant is more likely than not that he's more liable to the plaintiff. If it's let's say a car accident or, invasion of privacy. Let's take the O.J. Simpson case. I'm sure you've all are aware, even though it's way before your actual time, but if you're in criminal law, criminal justice, must have heard of the O.J. Simpson case. There was the criminal trial, right? He's allegedly killed his ex-wife and her friend. But along with the criminal trial was a civil trial for wrongful death. And while we all know he successfully was acquitted of his criminal trial, he was found liable in the wrongful death action under a lot of the same evidence. Why is that? Because the burden of proof is lower than it is for a criminal case. So this 51-49, my little scale, slightly above, a tad bit more than the other side. You see this preponderance of the evidence with civil cases. You also see it in probation proceedings, parole type proceedings, which we won't talk about here. I don't know if you've crossed paths with it in any of your other courses. And defenses. If there is a defense that the defendant wants to put on in a criminal case, their burden is never going to be beyond a reasonable doubt. Their burden is going to be by a preponderance of the evidence. Okay? So this criminal, beyond a reason, the standard that the prosecutor has beyond a reasonable doubt is quite high. But what does it mean? That the defendant probably did it, possibly did it, maybe. That there's no doubt in your mind? Absolute doubt? Is there such a thing as absolute doubt that the person committed a crime? How do we determine what beyond a reasonable doubt is? We know it's an extremely high standard. And the defendant doesn't have to put anything forth. He has a constitutional right to the presumption of innocence. It's in our Constitution. They're not required to testify. They have the right to remain silent. You don't get to hear, if you're a jury member, you don't get to hear his or her side of the case, even if you're dying to hear it. Oh, I just want to hear the other side. Everyone always wants to hear the other side. The defense doesn't have to prove their innocence. They don't have to prove they're not guilty. And that fact cannot be used against them. You can't go in the jury room and say, well, he didn't tell us his side of the story, so he must be guilty. No, can't be used against him. And that's an instruction the court will give someone. So what is this? The government has to prove with all of their evidence that the defendant is guilty beyond a reasonable doubt. I think the best way I'm going to show you is I'm going to tell you what the New York State jury instruction is. If you were sitting on a jury and you've just heard an entire case, maybe it lasted 3 days, maybe it lasted 2 weeks, the judge at the end is going to read some instructions. And one of the instructions is what beyond a reasonable doubt sort of means. So if you were sitting there, this is what you would hear. Bear with me. The law uses the term proof beyond a reasonable doubt to tell you how convincing the evidence of guilt must be to permit a verdict of guilty. The law recognizes that in dealing with human affairs, there are very few things in this world that we know are absolutely certain. Therefore, the law does not require the people, that's the prosecution, the people to prove a defendant guilty beyond all possible doubt. On the other hand, it is not sufficient to prove that the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest doubt of the defendant's guilt for which a reason exists based upon the nature and quality of the evidence. It is an actual doubt, not an imaginary doubt. It is a doubt that a reasonable person acting in a manner of this importance would be likely to entertain because of the evidence that was presented or because of the lack of convincing evidence. Proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of the defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed that crime. In determining whether or not the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of that evidence. So that is what a jury would hear on the meaning of reasonable doubt. So we can say no to absolute doubt. We can say no to possible. I like the language of proof of guilt beyond a reasonable doubt as proof that leaves you so firmly convinced of the defendant's guilt that you have no reasonable doubt of the existence of a crime committed and the defendant was the one that committed it. So that is our discussion on the burden of proof. We are going to talk about evidence next. Inferences, part of evidence. Another little interesting thing that a jury has to determine. So how do we get there? They have to make inferences and they have to make presumptions. What does a party need to establish to meet their burden? They need these two things. They need an inference. Based on the circumstances, we reach a conclusion. You don't have to make that inference, but you may. An example, the prosecution shows that the defendant punched the victim in the face after the victim screamed, "I hate you," at him. So what do you conclude from that? Can you include intended? Because that's an element. Yeah, I intended to punch him. You don't have the defendant saying, yeah, I intended to punch him. You're making an inference. The prosecution shows you that the victim, that the defendant punched the victim in the face, because the victim testifies, right? He points to the defendant, he punched me in the face. Well, when did he punch you in the face? Well, right after I screamed, "I hate you." So what's the inference? The fact that he says, "I hate you," and you get a punch in the face, shows intent. It doesn't say intent, but you make that logical inference. So I want to show you one more jury instruction that I think will clear up this inference, right? In evaluating, this is something that a judge will tell a jury, in evaluating the evidence, you may consider any fact that is proven and any inference which you may be drawn from that fact. So to draw an inference means to infer, to find, conclude that a fact exists or does not exist based upon proof of some other facts. So in that little example above, so we had two facts. Victim screamed, "I hated you." Defendant punched him in the face. So for example, let's take this inference. For example, you go to bed one night when it's not raining. When you wake up in the morning, you look out the window. You do not see rain, but you see that the street and sidewalk are wet and that people are wearing raincoats and carrying umbrellas. Under those circumstances, it may be reasonable for you to infer or to conclude that it rained. So in other words, the fact of it having rained while you were asleep is an inference that might be drawn from the proven facts of the presence of the water on the street and on the sidewalks and the people in raincoats and carrying the umbrellas. If you have any questions on that, you could, on anything, by the way, send me an email. We can talk. Sometimes the burden of proof and these inferences and presumptions and the evidence kind of get a little muddied. Presumptions. Presumption is a conclusion that the jury or the judge must make. What's a presumption? I just told you one. The defendant is presumed innocent in a criminal trial. They have got to take that with them. They're presumed innocent. It's not because, oh, he was charged, so he must be guilty. No, presumed innocence. That's a presumption you have to take. And what's important about a presumption, about a criminal defendant? When I ask you, that's it. When I say allegedly commit murder, it's not guilty all the way through trial, right? Allegedly, all the way through. The prosecution's goal is to overcome that presumption. And when they do, or how they do, is they have to present evidence and give you enough evidence, or a trier of fact enough evidence to make inferences that would lead them to a conclusion of guilty beyond a reasonable doubt. All right. Types of evidence. We have two types of evidence. And you need sufficient evidence to convict a defendant. We have something called direct evidence. We have something that is circumstantial. Let's start with direct. Direct means to directly prove a fact. You have an eyewitness that saw it all go down. That's direct evidence. You have a confession from the defendant committing the crime. That's direct evidence. You have a photograph or a video of the crime being committed. That's direct evidence. Like you don't have to raise any inferences. You see it. It's right there. Oh, he did it. Look, it's on video. Is this the best evidence to have? Some folks might say, oh yeah, you got an eyewitness. But what if that witness is lying? What if that witness gets caught lying? What if the video is not really good? It kind of looks like the defendant, but maybe it's not really. Maybe it's like some person with the same haircut, same color jacket. Is that reliable enough? Do witnesses sometimes not tell the truth? Or have you ever, how about an eyewitness who, we don't have to suggest they lie one way or the other, but what if, you see something so quickly? If you show 3 people something in a split second, you're probably going to get 3 different stories. Did that witness take down the accurate information? So it's not always the best, but it's certainly something that the juries do listen to. Is, you got an eyewitness, we got to listen to this person. Or there's a video, we really got to look at that video, because they like to just say there it is versus try and make inferences. So circumstantial evidence, and that's the evidence that indirectly proves a fact. Remember my rain example above? Direct evidence is evidence of a fact based on a witness's personal knowledge or observation of a fact. A person's guilt of a charged crime may be proven by direct evidence if, standing alone, that evidence satisfies a jury beyond a reasonable doubt. Circumstantial evidence is direct evidence of a fact from which a person may reasonably infer the existence or non-existence of another fact. A person's guilt of a charged crime may be proven by circumstantial evidence if that evidence, while not directly establishing guilt, gives rise to an inference of guilt beyond a reasonable doubt. Some examples of circumstantial evidence: fingerprints, DNA, blood, lab test, blood. What does it prove if you find these things there? That the defendant was there at some point, but it doesn't show that the defendant actually committed the crime, right? It's circumstantial. If you got a defendant's fingerprints at the crime, maybe there's some other explanation as to why the fingerprints are there. If we're dealing with a domestic incident that ended up in somebody's death, oh, well, we found the spouse's fingerprints. Well, of course you are, because if it was committed at the house, of course you are, because they live there, right? You're going to find their DNA. Blood's a little different. But remember, there these two types. These are the only two types of evidence: direct and circumstantial. Why don't you think about which one you think would be better or more reliable? And are there pros and cons to each?